Okay, good morning, everyone. Today I'm going to be presenting my topic on wills, powers of attorneys, and estates and real estate transactions. Okay, so I see we have quite a few number of people attending today. That's great. Okay, so let's move on. I won't introduce myself because I think you guys already know who I am. I'm the lawyer that's upstairs on the second floor of this building. Okay, so let's go ahead. Okay, let's go through and talk about what is a will and what is a continuing power of attorney for property. A will is a legal document to deal with your assets and properties, financial affairs, such as the payment of debts and taxes, and your children's welfare after your death. The will itself is effective only once you pass away, once you die, okay? So that's the effective date of the will. Before, before your death, the will is not effective. Now, we're also going to talk about a continuing power of attorney for property, which is also a legal document to deal with your assets and properties and financial affairs before your death, while you are mentally incapable of or physically unable to make decisions concerning your assets and properties. The power of attorney for property is terminated once you pass away. So upon your death, it is no longer effective. Okay. There's another type of power of attorney. It's called power of attorney for personal care. That deals with your personal care decisions, such as your health, where you're going to be residing, your shelter, your nutrition, your medical needs. That document we're not going to talk about because I don't think it's that relevant for you guys as agents. Right? Just be aware that there is a second power of attorney. It is a power of attorney for personal care, but we're not going to deal with that document because I don't think you guys are going to come across that while you guys are, during your course of your dealings with real estate. And if you have any questions, feel free to interrupt and just to let me know what your questions are. Okay, and I'll try to answer them. Now, a power of attorney becomes a continuing power of attorney for property if it specifies that it can be exercised upon your mental incapacity. Okay, so the power of attorney needs to actually say in the document itself that it can be exercised upon your mental incapacity. If it does not say this, then it becomes a general power of attorney and will also terminate upon your mental incapacity. So right now, a power of attorney is a general power of attorney if it doesn't say that it can be exercised upon your mental incapacity. Okay, and then that general power of attorney is terminated upon your mental incapacity. But I think probably all the powers of attorneys you're going to see now will be a continuing power of attorney for property. And the difference between a continuing power of attorney for property and a general power of attorney is that a continuing power of attorney requires 2 witnesses, whereas a general power of attorney only requires 1. So that's where you kind of get the requirement that there's 2 witnesses that's needed for power of attorney. You can actually have a general power of attorney with 1 witness, but all the powers of attorneys that I see now are continuing powers of attorneys that require 2 witnesses. Okay, is everything, I guess everybody's good so far. We don't have any questions. So let's move on. Now, who can make a will and a power of attorney? Anyone who is at least 18 years of age or older and is mentally capable. So you have to take a note of the second requirement, that you have to be mentally capable in order to make these documents. A lot of times I will see people who don't have the mental capacity to give instructions to me to prepare a will or power of attorney. We're talking about people who may have dementia, who may have early stages of Alzheimer, who are maybe elderly in their 70s or their 80s, and they're kind of losing their mental capacity. Once they've lost the mental capacity, they're not able to make a will or a power of attorney. Okay, basically they cannot make these documents. So just take a note that if you are recommending people to do these documents, if you're recommending your clients to do a will or power of attorney, just tell them, to do it relatively quickly, especially if they're elderly. So that way they still have the mental capacity to make these documents. Okay, and so far everything is good. I guess we don't have any questions. Now, both a will and a power of attorney made and signed in Ontario are effective in Ontario only. It may not be effective in other jurisdictions. So if somebody was to come to me and ask me to prepare up a will or a power of attorney, I have to give them the caveat that these documents that I'm preparing are only good for Ontario and may not be used in other jurisdictions, such as China or such as some states in the US. Okay, they may not accept my documents, the ones that I'm doing now. So just make a note of that, because I know a lot of you may have clients who are like overseas, from overseas. And if they do make these documents, just make sure you tell them they're only good for Ontario. Okay, they're not. They may not be used in other jurisdictions. Now, the person that's making the will is called the testator, and the person that's making the POA is called the grantor. And the person that's acting under a will is called the estate trustee, and the person that's acting under a power of attorney is called the attorney. Okay, just so you get the terminology right. Okay, so when I'm talking about a testator, a grantor, the estate trustee, or the attorney, so you will know who I'm referring to. Now, this is what I talked about this earlier. Both the will and the power of attorney require two persons to act as a witness to either the testator or the grantor's signature. Note that certain persons should not act as a witness. So if you're going to be a beneficiary under the will, you cannot be a witness. And also the spouse of a beneficiary cannot be a witness under the will. Okay, they will automatically lose their entitlement under the will, because basically what we're worried about is we're worried that the grantor, or sorry, the testator in a will, is not being unduly influenced. So we want two independent witnesses to be there to witness his signature, and then later on, maybe these witnesses would be required to testify under court that there was no undue influence. So this is why we don't want people who are going to be beneficiaries to be witnesses. Okay, it makes sense. Okay, and once you make a will or power of attorney, you can always revoke the document, but the revocation has to be in writing, right? So it's not good enough that you just tear up the will or the power of attorney. You actually have to revoke it by making another document, a revocation document that revokes either the will or the power of attorney. And the will and the power of attorney must be signed freely without duress or undue influence. That's kind of obvious, okay? You don't want people to be signing these documents, which are very important. You don't want them to be unduly influenced by a relative. Like you don't want, for example, one of the parents, like let's say a father, to be unduly influenced by one of the children to say, give me everything, right? Like, then that's not being done freely. So the power of attorney can deal with all, some, or one of the grantor's properties. So the power of attorney can be an unlimited power of attorney, meaning that it deals with all of the grantor's properties, or it could be limited to one property. Let's say the grantor's real estate, one of his properties. And the properties that could be dealt with in a power of attorney could include both personal properties, such as bank accounts, stocks and cars, and real estate. Similarly, the will can also deal with some, all, or one of the testator's properties, but will usually include all of the testator's properties for practical reasons. You don't want any properties to be left out once the testator has passed away. So this is why almost all wills that I see would deal with all of the testator's properties. In a will, the beneficiaries, okay, the people who are entitled to receive the testator's properties, are usually the testator's relatives. In a POA, although not named, the beneficiary is really the grantor. In other words, the attorney in a power of attorney must always be acting in the best interest of the grantors when exercising a power of attorney. And the attorney can be required to account for all transactions conducted through the POA. Okay, just as a point of interest, a lot of times I will see people getting a power of attorney because they don't really want to go on title for some reason. They don't want to go on the title of the property because either they want to avoid any potential liability to judgment, or they maybe for financing, okay, they cannot go on title to the property because they're already on title for other properties, and maybe they're limited in terms of financing. So a lot of times you'll see people who don't want to go on title, but they will get a POA from the person that is going on title to say that, like to say that to appoint them as the attorney. So that way they feel like anytime they want the property back, they can just use the POA to get the property back. So they will just sign and say, I hereby, I'm acting for the person who's on title, but I'm going to transfer the property back to myself. So I will see this from time to time. Okay, it doesn't happen very often, but I will see that the person who is really the true owner of the property, he will get a power of attorney from the person who's on title, and they feel like that anytime they can get the property back, they just go to a lawyer and say, I'm going to exercise a POA and I'm going to have the property transferred back to me. Okay, that's a no-no. Okay, that is that cannot be done. All right, the attorney cannot use the POA to get the property back or transfer it into his own name, into his or her own name. Okay, they always have to be acting in the best interest of the grantor when exercising POA. Right, so just make a note of that. Okay, I have come across that a couple of times during my practice where the attorney is really the owner of the property and feels that through the POA they can get the property back. All right, they cannot do that. That is not the way to use the POA. Okay, if the attorney is really the owner of the property, okay, there's other ways that they can go about it to show that they're really the owner of the property. They can do a trust agreement, for example, okay, to signify that they have an interest in the property, but they cannot do it through the POA. Okay, okay, we might have a question. I guess it's Julio Lin.
Yes, hi, how are you?
Not
I have
too bad.
a question. So for the estate trustee, can the estate trustee also to be the beneficiary for the property? So here's a case. I have a client. Okay, so her mother.
Actually, sorry, Julio, you're talking about a will situation, right?
Yes.
Okay, so the owner has passed away. Then is that correct?
The owner has passed away.
Okay.
So when the owner passed away, she didn't leave a will. So her daughter later on already got the certificate of appointment of estate trustee without a will from the Supreme Court of Ontario.
Okay, go on.
So basically the daughter, my client, also she's going to, so with this certificate that she got from the Supreme Court of Justice in Ontario, can she receive this property as a beneficiary?
Well, it depends, though. I mean, is she the only child?
She is, yes.
She's the only child?
Actually, she has a sister in China, but before they do this application with the court, her sister already signed to give up this property to her, to my client. So she will be the only. So she will be the only child who received this property from her mother.
Yeah. The case itself sounds a little bit complicated because usually all the children would be entitled to, if there's no will, if there's no will, and the spouse has passed away, so I assume that the mother has died, right? Or has predeceased.
Yes. The father died earlier than mother. So then.
Okay. So we're talking about the mother now, right?
Yeah. So basically, no. When the mother of my client bought this house, at that time, the father already passed away. So
okay.
The mother bought this house under her name, under her mother's name. The mother passed away without a will. So then her sister already at that time when she came over to do this kind of the farewell. So her sister also signed in front of the lawyer to give up this property to my client.
I think that the sister should have got independent legal advice. Okay. To give up her interest, because I mean to give up your interest in the house is pretty serious. And I think she should have gotten independent legal advice.
Her sister voluntarily agreed to give up this.
Yeah, but then her sister should have got the advice of another lawyer to.
But anyway, so the the lawyer who's applying for this Supreme Court certificate of estate trustee at that time already got the signature signed by my
okay,
client's
but
sister.
anyway, I think I don't think I want to comment on this because I like it's a little bit. It sounds a little bit complicated.
Yeah. So anyway,
Okay.
my question is, my client.
Yeah, Julio. Yeah, I don't really want to comment on this because another lawyer is doing this. This, is handling this right now. So like I don't really have the facts of the case. I don't really want to comment on what the other lawyers should have or should not have done. So if it's possible, maybe like I don't want to do this over the seminar. Maybe it's possible you can call me like maybe after the seminar, like and then discuss this so I can just maybe discuss it like privately with you.
Okay, so can I have a phone number? Sorry.
Yeah, it's actually I don't know if it's at the end. I have my contact information at the very end.
Okay.
At the very end. It'll be in the screen. I'll present. Sure. I'll show it to you. Okay.
Okay. Then.
Okay. Let's move on then. I guess we'll continue on. Okay. So both the attorney and the estate trustee are entitled to compensation in acting as an attorney or estate trustee.
哎，行行，哎呀，不好意思，刚才我在银行办事
啊，没事。
就你继续说，因为我什么你发那个文件什么的，我都还没有来得及看。你跟我讲一下子怎么回事？
现在就是说，现在是这个合同已经。
sorry. You guys
过期了，他现在没有答复嘛？但是呢，整个的过程你看，他就是零打碎敲的，一会儿问一个这个问题，一会儿问那个问题。
我们在开会。他们应该把麦克风关一下。
肯定是想等一个信号，拿我这个面底儿去找别人。对，这完全
sorry. If you guys are talking, maybe maybe you guys can maybe talk among yourselves because like
I think the host can mute all of the participants.
Okay, I'm trying to because Sammy's not here right now and somebody's talking. Somebody was talking. I'm not sure what they were doing, but like, how do I mute them? Like, so I think maybe they forgot they were on a seminar.
Peter, you can do that way. Who's talking? You unmute that guy.
Yeah, I'm not really familiar with this technology. Maybe
Okay.
you can help me and stay here. So that way, yeah, I'm not really familiar with this technology. Sorry. So Sammy is back, so he can help me to to deal with this if it happens again. Okay, so let's move on. Okay, so let's move on to the next slide. So far, everybody's good with what I'm speaking right now, right? Like, is there any questions about what we've talked about so far?
Yeah, it's fine so far, Peter. It's okay. Go ahead.
Yeah, everything is clear. Okay. So some special clauses which could be inserted into a will include the following. You can have a clause to set up trust for the testator's minor children because a lot of times you don't want the children to get the share right away, right? You want them to turn to a certain age before they can receive their shares, right? So you can set up a trust, right? So this is very useful because a lot of times the testator will pass away and they'll leave maybe a child that's maybe 14 or 15, and you don't want the that 14 or 15-year-old to be getting the share of the estate right away, right? Because you don't know what they're going to do with the money because a lot of times they're not mature enough to handle money. So basically, you would have set up a trust so that there'll be a third person, an adult. Usually, it's the estate trustee. They will hold on to the money for the 14 or 15-year-old until the child turns maybe 18 or 25, and then they will administer the that child's share until the child is old enough to handle money themselves. So that's one useful thing that could be done with a will. And then the other useful thing that you could put into the will is a clause is to exclude a testator's assets from becoming part of a beneficiary's net family property in the event that the beneficiary separates from his or her spouse. So that's very useful too. So you want to make sure that whatever money that the testator is giving to the beneficiary, that the spouse is not entitled to share in that money, all right, in case there's a separation. And then you can also have a clause to exclude any illegitimate children from sharing in a testator's estate. Okay, that's very useful too, because a lot of times you'll find that the children maybe from a past relationship that of the testator that may come and say, well, I'm basically a biological child of the testator. I'm entitled to share in the testator's estate. but really have nothing to do with the family. So you can also have this clause too to exclude any children who are born out of wedlock from sharing in the testator's estate. So those are just some of the clauses. There are other clauses as well, but these are just some of the clauses you can put into a will. Okay, so the will is very useful, and I've noticed that in particular with a lot of Chinese people, they don't really have a will, and it makes things very difficult because not only does it make things very difficult to decide who's going to be getting the properties, but in terms of getting probate, having a will makes things a lot more simple. Okay, to get the probate. If you die without a will, it becomes much more difficult to get the probate. And a lot of times, just be aware too that non-residents are not entitled to be appointed as an estate trustee without a will. So if you don't have a will and you want a non-resident to handle the testator's assets, want to be appointed as the estate trustee, that's not possible. By law, they are not entitled to be appointed as an estate trustee. So I've had a couple of cases where the testator passed away, did not have a will, and they have no immediate family in Ontario to be appointed as the estate trustee. So they would I guess the friends would ask me, oh, can we appoint somebody from overseas to be appointed as the estate trustee? And I said no. Okay, that's not allowed. So that makes things much more difficult. So it is really important that you tell your clients to have a will done. A will is not very expensive. It's normally maybe in a range of maybe $200 to $500, okay? But it does solve a lot of problems in the event that something happens to the testator and you need to use the will. Okay, so let's move on. And the same with the POA as well. We're going to talk about what happens if a person becomes mentally incapable and does not have a POA. This person would have to be assessed by an assessor to see if he or she is incapable of managing property. Usually the assessor is a doctor, okay, a psychiatrist. If the person is found to be incapable of managing property, a certificate is issued by the assessor, and then the public guardian trustee becomes that person's statutory guardian of property. So then basically the government would get involved, all right, and would be appointed as the statutory guardian of that person. So then the families, I guess the relatives of the person that's become mentally incapable would then have to make an appointment, would have to make an application to the PGT to replace the PGT as the incapable person's statutory guardian of property, accompanied by a management plan and a fee. This application is very onerous. It's very difficult. It's very time consuming. And also you have to have a management plan, and you also have to pay a fee too in order to replace a PGT as the incapable person's statutory guardian of property. So it's a lot of paperwork involved. There's a lot of costs involved, which all could be avoided if you have a POA. So just like the case with the will, okay, you always should have a POA, especially if you own any sort of real estate. If your client owns real estate, they should have a will and a POA for property, okay? In fact, that's always my recommendation to the client once they have completed the real estate purchase. I always tell them, you really should look into getting a will and a power of attorney done. And it's not that expensive. A POA may be about $100 to $150. And a will, like I said before, is maybe around $200 to $500. But it solves a lot of problems in case something happens to that person, okay? If that person becomes mentally incapable, if that person has to leave the jurisdiction, like leave Ontario for some reason, okay, needs somebody to deal with his or her property, or if that person dies, okay? In all these scenarios, you really need to have the POA and the will. Like I said, the application to replace the PGT as that person's statutory guardian of property is a long document, which is very time-consuming, intrusive, and expensive to complete. And if the application is not successful, let's say you apply to the PGT and they reject your application, you would then have to apply to the courts to be appointed as the court-appointed guardian of property. Okay, and that is very expensive. That's a very expensive process. With a POA, upon a certificate being issued certifying that the person is mentally incapable, the attorney can proceed to deal with the mentally incompetent person's properties and assets without applying to the PGT or the courts. So once you have the POA, you can avoid all these procedures and all these, like the time and the cost involved. So this is why it's really important if you have a client who has bought, like who owns real estate in Ontario, to get the POA and to also get the will done. And the same thing, what happens if a person dies and does not have a will? Some of the consequences include the estate trustee and the beneficiaries are determined by law and not by the testator's wishes. So let's say the testator wants to exclude one of his or her children from sharing the estate. Let's say that child, had a falling out with the testator, and the testator no longer wants that child to benefit. Okay, you need to then have a will in order to exclude that child. Otherwise, if you don't have a will, that child will be entitled to share in the estate as determined by law. Okay, and I already mentioned this before, but the probate process will take a considerably longer time. There will likely be more procedures to follow, and the cost to obtain probate will increase significantly. So if your client does not have a will, okay, you're looking at a longer process for probate. You're looking at more procedures to follow, and you're also looking at more costs to obtain the probate. And also, if the testator has a minor child or has children, then the court process to appoint a guardian for the minor child children will take a longer time and be more complex and expensive since the court does not know the testator's wishes. So let's say the testator passes away and has, say, a 9-year-old child. Obviously, you need somebody to be appointed to be the guardian of that child. Now, in the will itself, we would actually put in the will itself, who the testator wants to appoint as the guardian. If you don't have the will, then nobody knows who the testator wants to appoint as the guardian. And then the court will usually have to do a more involved process. They have to look at the situation more in order to determine who is best to be appointed as the guardian. But if the court has the testator's wishes as specified in a will, like this person will be my guardian, then the court is pretty, feels more comfortable in appointing that person because they already know they're going to follow what the testator wishes because they will think that the testator knows what is best, who is best to be appointed as the guardian, right? So the process becomes much more simplified and much less complicated if you have a will. And that will appoint somebody to be the guardian of the minor child children. And without a will, the deceased person will not have the benefits of the special clauses that we discussed earlier to suit that person's preferences and make that person's estate more efficient, less time-consuming, and less expensive to administer. So just remember, okay, the cost of doing a will and a power of attorney will be less than the cost to do either the application to the PGT or the probate process if you don't have a power of attorney or you don't have a will. So you're really going to be saving money by having these documents. All right, you're going to save money and you're going to save time and you're going to save stress if you have a will and a power of attorney. So like I said, anybody who has real estate, who owns real estate in Ontario should have both documents. Okay, now we're going to talk about, I guess, a little bit more practical situation about what you may encounter as real estate agents, okay, when you go to sell or buy property, okay? If in the event of an owner's death, you need to examine how title is held to determine how to deal with that owner's real estate. If the owner held the property with someone else as a joint tenant, then title will automatically vest in that other person upon registration of a survivorship application. It's a simple procedure. So if you have 2 or more people holding title as joint tenants, okay, this is very important to know, as joint tenants, okay, then if one person dies, all you need to do is you need to just register a survivorship application, which is a very simple application, okay? All you really need is just the death certificate of that person. Then you can then have that person removed from title, and then the remaining owners will become the owners of the property. So it's a very easy process, okay? Now, this is what I always recommend, okay? Especially in a spousal situation, in a husband and wife situation, we always register the property as joint tenants. That way, if the husband dies, then the property will automatically go to the wife by registration of the survivorship application without the need to go to probate. Okay. If the owner held property or held title, sorry, as a sole owner or as a tenant in common with another person, tenancy in common is where each owner owns a specific percentage of the property. Then in this particular case, you need to obtain probate in order to deal with the property within 3 years of the owner's death. So in this particular case, where you have person just owning the property as a sole owner, or where they own the property as a tenant in common, then you don't have this right of survivorship, okay? And then you don't have this title automatically vesting in the other owners, okay? Because there is no other owners, okay? Or there is no right of survivorship. Then you will need to get probate in order to deal with the property. Okay, so if you're an agent, as an agent, so if somebody comes to you and and says, oh, one of the owners the owner have passed away, you need to look at how the title is held in order to deal with that owner's real estate. Okay, so if the property is held with someone else as a joint tenant, then you don't have a problem. You just basically have to register a survivorship application, and then that deceased owner will be removed from title. But if the owner held title as a sole owner or as a tenant in common, then you got to go through probate. Okay. Probate is a process where someone applies to the court to be appointed as an estate trustee with or without a will in order to deal with the deceased person's properties and assets. Probate is really the court conferring authority to the estate trustee to deal with the deceased person's properties and assets. The probate process will take time. It may take several months. Just remember that with a will, probate will take less time, be simpler, and be less expensive to obtain. Okay. Okay, we have another question from Helen. All Ontarian only house is under wife's name. Does the house will include in fee of probate? Okay, if I think this is just what we talked about earlier. Okay, if the wife is the only owner of the property and the wife passes away, yes, then you need to get probate in order to deal with the wife's property within 3 years. There is a procedure where if the person has passed away, if the owner has passed away for more than 3 years, like more than 3 years have passed since the deceased owner died, then there's another way to get the property transferred into the beneficiary's name. There's another procedure. But if you want to deal with the property within a 3-year time period of when the owner has passed away, then you need to go through probate. The other procedure, it's a little bit complicated legally speaking, so I won't deal with that. Okay, but just be aware that if the owner has passed away for more than 3 years, then there is another procedure to get the property transferred into the beneficiary's name without going through probate. Okay, and then you should speak to a lawyer about that too. Okay, more than 3 years have passed. Oh, okay. I think Helen came back and asked me, does it matter whether it's a primary residence? No, it doesn't matter. If the wife has passed away and and she's the only owner of the property, then you need to go through probate if you want to deal with the property within the 3 years of her death. Okay. Now, I have done a couple of cases where, oh, excuse me, let me just get a drink of water here because I'm getting a little bit, my mouth is getting a little bit sore here. Okay, sorry about that. Okay, so I have come across a couple of cases where I have one parent on title, the other parent has passed away, and 2 or 3 of the children are living at that property with the parent. So let's say the parent is living at property A, and at the same time, the parent's son, for example, may be living a property as well. Normally speaking, to avoid probate, what I might do, okay, what I might recommend to the parent is to add the child on title now, okay, to add the child on title now, especially if there's no mortgage on the property, because you don't have to pay any land transfer tax if there's no mortgage, okay? And then what I would do is then I would add the child on title, so then the title would become the parent and the child as joint tenants. So that way, if the parent dies, then the property will automatically go to that child without going through probate, because like I said, there's a right of survivorship, okay, and the property will just go straight to that child by registration of a survivorship application. But the thing is, you got to make sure that the child's living at the property, so that property becomes the child's principal residence. So just to avoid any capital gains issues, okay? Because if the child's not living at that property and the child has another property, let's say the child has his or her own property, then if he goes on title to the parent's house, then that property would become his second property, and you can only have one property as your principal residence. So I have done this in a couple of cases where the child is still living at that home and can declare that property to be his or her principal residence. In that case, it might make sense to add that child on as on title as a joint tenant. Okay. Okay, so let's move on. Now, there are probate fees which are payable at the time when you're applying for probate. The probate fees, they're formerly known now as the estate administration tax, are payable as follows. There is no estate administration tax payable if the value of the estate is $50,000 or less. For estates with a value of more than $50,000, the tax is calculated as $15 for every 1,000 or part thereof of the value of the estate exceeding $50,000. So I just did a simple calculation here. The estate administration tax payable on an estate with a value of 1 million, for example, would be $14,250. So it would be $15 times 950,000 divided by 1,000. Okay. Now the 14,250 is still quite a lot of money. Okay. So like I said, you want to try to avoid probate fees or the estate administration tax if you can. Now, I have also noticed that some real estate agents have proceeded to sell a property conditional upon probate being obtained. This is kind of a little bit risky because the time to obtain probate is uncertain. I have had cases where it took only 2 weeks to obtain probate from the time that I applied to the court to get probate and when the certificate of appointment is issued. Okay, it only took about 2 weeks. And there are some cases where I've heard that from lawyers that it's taken 10 months to obtain probate. So it's a bit of a risk to sit there and make the sale of a property conditional upon probate being obtained, because there's no guarantee when you're going to get that probate. Okay, and then if there's a dispute between the beneficiaries as to the entitlement, for example, some beneficiary may feel I'm entitled to more money, or if there's a dispute on the will itself, that will make probate very difficult to obtain. So like you're not quite sure how long it's going to take to get probate, and you're not quite sure whether the beneficiaries are going to be involved in a dispute about the will itself. Okay, and if there is a dispute between the beneficiaries, or if the court is very slow in granting probate, then it's going to take a long time to get the probate. So it's very risky to make the sale conditional upon probate being obtained. It's a better practice to have the probate, to get the probate obtained, and then to sell the property. Okay, and note that the seller in an estate sale transaction is the estate trustee. So for example, the seller in the agreement of purchase and sale for an estate sale should always be listed as John Doe as the estate trustee for the estate of, and then the registered owner. This is the proper way to list the seller in an estate sale. Okay, I have seen so many different ways that the real estate agents have been using to list as the seller, but the proper way is to say John Doe as estate trustee for the estate of, and then you have the registered owner, okay? The name of the registered owner here. Okay, you also need to review the terms of the will, if there is a will, to ensure that the property has not been specifically gifted to a beneficiary. In some wills, they will actually gift the like the testator will actually gift the property directly to a beneficiary. Okay, you need to check the will to make sure that that hasn't been done. Because if that has been done, then the property will automatically be transferred to that beneficiary once probate has been obtained. Okay, you also need to make sure that the estate trustee has the power to sell real estate. So my suggestion is if you're dealing with in a case of an estate sale, and you know that there's a will, you should bring that will to the lawyer to review the will itself to make sure that, like that the estate trustee has the power to sell the real estate and that is the property has not been gifted to a particular beneficiary. Also, you should keep in mind that the estate trustee does not have knowledge of the property. So do not include any warranties such as no debts in the property, the chattels and fixtures are in working order, or the no work orders, or declarations such as a survey declaration, any agreement put in sale. Okay, so because the estate trustee often doesn't live on the property, they're not going to have any knowledge of these warranties or these declarations. So make sure that if you're acting for the estate trustee in a sale, that you don't have these clauses in the agreement. Okay, we have another question from Aaron. Okay, if now add owner's daughter, non-resident to title by joint tenants, is land transfer tax required right away? Home is mortgage free. I do not recommend to do this because if it's a non-resident and she's going on title, the property cannot be the principal residence of this non-resident. A non-resident cannot declare this property to be his or her principal residence because they're a non-resident. They're not living at the property. So there will be tax implications if you do add that daughter on title. So I always recommend in case of non-residents to consult an accountant to see whether to add the daughter on title, whether that can proceed on a tax-free basis. And my feeling on that is probably no. Okay, so I hope that answers Aaron's question. Okay. Aaron, are you okay with the answer or? Okay, I don't have a response from Aaron, so maybe I'll deal with him after the seminar. Okay, now the tips regarding the use of the POA. Okay, these are just some tips that you should keep in mind. First thing is the most obvious is do not draft the POA yourself. Okay. Okay, get it done at a lawyer's office. Okay, Aaron's replied back and he says yes. Okay, thank you. Okay, so let's move on. Do not draft the POA yourself, which is very obvious. You're not a lawyer. Okay, you're real estate agents. Do not prepare the POA yourself. It should be done by a lawyer. And then if the POA was not signed in a lawyer's office, ask why not. If the POA was not signed in a lawyer's office, you're going to have a much more difficult time using the POA because people are afraid, of fraud situations. They feel more comfortable if the POA was signed in a lawyer's office. Okay, that way we know that the lawyer has verified the grantor's identity, that there's no undue influence. Okay, so the practice now is if you're going to get a POA done, is to get it signed in a lawyer's office. Okay. Do not act as an attorney for your client. Okay, I highly recommend you don't do that. Okay, actually, I have another question from Helen. Does holograph handwriting will work smoothly in practice? To be honest, in the course of my career, I've only come across one holograph will, and that holograph will gave me a lot of problems in getting probate. So my suggestion is don't do a holograph will, get a will done by a lawyer. Okay. So no, it does not really work smoothly in practice. Okay, that's my one experience with the holograph will that I have done. Okay. Be aware of any suspicious circumstances surrounding POA, such as duress or undue influence. Okay, so if you have a child pushing the parent to sign a POA, okay, then you should be a little bit suspicious of that. You don't know what's the intent behind that. So just keep in mind that, when a POA is done, just keep in mind, is there any pressure being put on the grantor to sign the POA, to get the POA done? Keep in mind that the attorney should be someone that the grantor has a high level of trust and confidence. Well, okay, that's kind of obvious. Okay, if you are required to act as an attorney, which I do not recommend, okay, which I strongly do not recommend, you should always get instructions from your client before proceeding to act for that client. So if the client, if you are required to act as an attorney, which I don't suggest you do, I don't know what is the practice with Home Life Landmark, whether they actually allow you to act as an attorney, but my suggestion would be you don't act as an attorney. But for some reason, if you're required to act as an attorney, you should always get the client's instructions, especially with the offer, okay? You should always get it in writing and have it put in email as to whether or not they accept the price, whether they accept the offer or not, whether they accept the terms. You should always get that in writing, okay? But my suggestion would be you just don't act as the attorney, okay? Especially nowadays, you can always send the offer to the client directly, through WeChat, WhatsApp, email, right? So they can always look at the offer themselves and then decide for themselves whether they want to sign back or not. And you can always get them to sign back, through the platforms, right? You can always get them to sign back and then send the document back to the platform. So it's really no need for you to act as an attorney in a power attorney, okay? In any sort of in any transaction. Okay, you should always make sure that the attorney is prepared to act. There have been cases where the attorney does not want to act under a POA, and then the attorney is not required to act. Okay, just because you name somebody as the attorney doesn't mean that the attorney is required to act as the attorney. Okay, the attorney may refuse to act. In other words, okay, they may refuse to act. In which case, the power of attorney is kind of useless because you don't have the attorney acting. Tell your client that he or she will need to provide photo ID when he or she makes the POA. Okay, that's part of the client identification process. You should make sure that the POA should be limited to the real estate transaction in question. Do not make the POA broad in nature to avoid any misuse. So the POA should be for a specific purpose. It shouldn't be a broad general power attorney that allows the attorney to deal with all of the grantor's properties. There's no need for that. Okay, the attorney should only be needed to complete the real estate transaction in question and nothing else. The POA should also be expressly time limited, i.e. the POA should expire on a certain date in order to avoid any misuse. Okay, that makes sense. Okay, if the attorney is signing your agreement of purchase and sale, underneath the execution line, it should say John Smith signed by Jane Doe under power of attorney. And you should also attach a copy of the POA to the agreement. So that way the other party is satisfied that the POA, that there is a POA and that it's legal, and that the attorney does have the authority to sign on behalf of the grantor or the registered owner. If the purchaser is arranging mortgage financing, make sure that the POA is approved by the bank/mortgage company before the deal is firm. Some banks, in fact, most banks that I know, and most lenders will not allow the use of a POA. So you have to confirm with the bank or the lender that the POA is acceptable. Keep in mind that the POA should be executed or signed in a lawyer's office in Ontario to avoid any potential issues during the transaction. A lot of the title insurance companies want the POA to be signed in a lawyer's office. Okay, that way they feel confident that the POA is a legit POA, that the grantor's identification has been verified, and that there's no undue influence or fraud involved. Okay, so if you are required to use a POA in a transaction, just make sure that it's signed in a lawyer's office. And on a real estate sale, the sale proceeds after you deduct real estate commissions, lawyer fees, and mortgage payouts will always be made payable to the grantor seller, not to the attorney. Okay, this is just to avoid any fraud. All right, we want the money to go directly to the registered owner, the seller, and not to the attorney. Okay, just to avoid any fraud issues. Okay, it's kind of obvious. Make sure that the POA has the correct name spelled correctly, has 2 witnesses, and is properly drafted. Okay, make sure that the wording is done right. Okay, I've seen some really poorly drafted POAs where the property address to be dealt with it's actually spelled incorrectly. It's actually incorrect. Okay, and that can cause a lot of problems. Okay, like I just make sure that the POA is properly drafted. Okay, to avoid any potential issues, like when we go to close the transaction, has 2 witnesses and that the names are correct, spelled correctly. The name on the POA should match the registered owner's name. All right, so the grantor's name and the registered owner's name should be the same. Okay. And finally, the use of the POA should always be the exception, not the rule. It should only be used in exceptional circumstances. So we don't think the POA, is a good substitute. Okay, it's not. Okay, it should only be used in exceptional circumstances. And thank you for attending my seminar. I hope I've been a little bit useful, that you guys actually have learned something from it. And if you have any questions, you can feel free to contact me. And I thought actually my contact information would be at the back, but it's not. But just feel free to email me. My email is very easy. It's just peterchai@rogers.com, my first name and my last name combined together, and it's @rogers.com. So if you guys have any questions, anything you don't feel that, or you need me to explain something a little bit further in the, from the seminar, just feel free to email me and I'll try to get back to you. Okay, we have another question. It says here, would the last will supersede any previous wills for the same assets intended to divide to? Thank you. Okay. The last will, okay, the most recent will should always have a clause in that will saying that it revokes any previous wills. So practically speaking, the last will that was drafted should be the most current will. Okay. So the most current will is probably the one you should rely upon, because like I said, the will itself will always revoke any previous wills, or it should at least have that clause. Okay, is it okay? Do we have any other questions? Anything that people are not sure about? Anything that you feel free to ask.
Yes, Peter, this is David here. Can I ask a couple questions here?
Oh, sure, go ahead.
Yeah, because Sammy, Tony, and myself always asked by our agent from time to time regarding POA. So I can ask you if you can give us some good suggestion. If we are the listing agent, what we can do? If we are the buyer agent, what we better for us to do?
Oh, I think I gave all the tips, like all these tips here. The tips regarding the use of the POA, I think we went through this. Like those are the tips I would suggest you to do. I mean, obviously the most important is don't act as the attorney for your client, right? You don't want that extra liability, right? Make sure that the POA is signed in a lawyer's office. Okay, that's very important. Okay, just to make sure that the transaction will go smoothly. Make sure that the POA is intended only for the property you're dealing with. It's not a general power attorney. Make sure that it's time limited, okay, so that it should expire on a certain date to avoid any misuse. Okay, make sure that the POA is approved by any lenders, if you're acting for the buyer. Okay, so yeah, that's about it. I mean, I listed out all the tips in these screens here. So
you will send a copy to Sammy. Let our agent can share with it, right?
Sure. Yeah. Okay, that's fine. I could do that. Okay.
Yeah. And the other thing is, because sometimes the POA, the people is overseas. So when they do the POA, if it's prepared by you in Toronto, how can they get the sign for the people in China somewhere?
Well, that's a good question. If they're Canadian citizens, I would ask that they go to the Canadian embassy or the Canadian consulate and get it witnessed by one of the consular officials. That way, I have some trust that like that it was done in front of a public official. Or I would suggest that they go to a Canadian or a U.S. law firm or a British law firm to get it witnessed by a lawyer that's that's from a Britain or from a U.S. or from Canada. Okay. For some reason, a lot of the title insurance companies and the lenders do not like it if it's witnessed by a Chinese notary public or a Chinese lawyer. For some reason, they don't like that. So my suggestion would be is if they're in China, to get it done either at the Canadian embassy or the Canadian consulate to witness, or to go to a Western country's law firm to get it done. Yeah, to get it witnessed. So
can you do the virtual signing yourself in your office?
Yeah, you can do that as well. Although a lot of times the owner may it's very difficult to connect with the owner because the owner may due to the time difference, and the owner may actually be working or be traveling. So it may be very difficult to connect with the owner in order to sign the document. You could use virtual signing as well. Okay, in fact, that virtual signing should now kind of replace the POA, because if the lawyer can meet directly with the owner to sign the document, that should be fine as well.
Okay, good. Thank you, Peter.
Okay, any other questions or anything else? Okay, can you post your phone number here to reach? Thank you. Okay, like I said, I don't really know how to use this technology, and Sammy is it's so new to me.
Okay, Peter, tell me what's your number. I can type here.
Okay, it's 905.
Okay.
305.
305.
6130.
6130. 30.
And I can give you my email as well. It's just my first name, Peter, and then Chai. It's all one word. PETERTSAI. Okay, and no underline, no underscore, nothing. Okay, so just Peter Chai at Rogers with an S.com. Do you mind just posting that too, David? So.
Yes.
Okay, so I usually don't like to comment on what some other lawyer is doing or has done. Like, that's not really it's not really very good for me to do that. I don't prefer to do that. But if you have a question, a general question about the seminar itself, or if you don't understand a certain point that I'm making, okay, then feel free to either contact me by phone or by email, and I'll try to explain a little bit better. I find that this virtual seminar, it's very difficult to do, because I can't really read people's reactions and see whether they really understand what I'm saying, because I don't see people, right? I'm just kind of speaking into a computer screen. So this is why I'm a little bit, I'm always asking people, do you understand this or not? So if you have something that you don't understand from the seminar itself, feel free to either email me or contact me by phone. Okay, and if you have a case that doesn't really involve a lawyer doing something, then yeah, by all means, give me a call and maybe tell me. But like I said, I try not to comment on what other lawyers are doing or what they're supposed to have done. Like, I really do not like to do that. Okay, because I don't think it's very professional, because I don't really know, the whole circumstance or the whole case. So I really don't want to sit there and say, what a lawyer has done or what he or she should have done. Like, that's not really very good. Okay. Okay, I think that's it. If anybody else has any other questions, or I guess we have a little bit more time, maybe another 5-10 minutes. If somebody else, I think that's it then. I don't see any other questions. So, okay, well, thanks for coming. And then I guess, maybe we'll get to talk to you guys again. Okay, thank you.
Thank you, Peter. Thank you.